All right, folks, how are you today? My name is Jason Steele, as you know. I am a licensed realtor here in the province of Ontario, and I've been a realtor for going on 17 years, 18 years, going on 18 years. I'm in my 18th year. Wow. Um, One thing I want to talk about is estates. Estates, when it comes to real estate and estates in general, a very, very, very important topic that people just don't talk about. And it's very time consuming. The complexities of the financial aspect, the paperwork is just incredible. And having the experience of having clients who are estate trustees and selling estates, right down to I'm currently an estate trustee. And so this is firsthand experience. Um, if I get a little emotional, it is what it is. Again, I'm dealing with an estate right now, and I wanted to share it because, man, it's difficult. It's shitty. It's scary. It's the whole world's coming at you, and there's not a ton of information if you don't know where you're looking. So here it goes. Being an estate trustee, and I'm doing some reading because I wrote stuff down so that I wouldn't miss anything. So if it looks like I'm reading, I am. Being an estate trustee, also known as an executor on the estate, it can be challenging. It can be very complex, and there's some reasons why. And there's a whole bunch of steps, but I'm going to start with the very first step because you need to take care of yourself. Managing an estate can be very overwhelming. It's crucial. You take time, you seek support, friends. I wouldn't suggest family because obviously you're a state trustee for the family. Unless you have a family member that you're very close to, or a couple family members you're very close to, like myself. Maybe get yourself a counselor, someone you can reach out to and talk to, because and I'm not trying to scare you, but being a state trustee can and will be stressful. You have, as an estate trustee, you have legal and administrative responsibilities for a wide range of legal and administrative tasks, including probate of the will. 9 times out of 10, there'll be real estate involved, there'll be monies involved. Probate has to be done. You have to identify the value of assets, pay the debts, pay the taxes, distributing the assets to the beneficiaries. And it's crazy because you have to navigate all the legal requirements and paperwork, and it can be so overwhelming, especially if you don't have a legal background. It can be very difficult, especially when there's multiple beneficiaries and especially family, which leads me to the next issue. There's a lot of emotional stress. I mean, I just lost my aunt this year, and dealing with the loss of a loved one while managing the practical aspects of their estate is draining. It is physically and emotionally draining. Estate trustees often find themselves mediating family disputes and managing the expectations of beneficiaries, and that's very stressful. They can also be at the center of the disputes. The estate trustee can be at the center of the dispute, whether from past family history, narcissistic behaviors from family members, and jealousy, period, that you've been given control of the estate. It can be, you know, from a family member, it could be from a long lost friend of the estate who figures they are entitled. And it sucks. It freaking sucks. And that's just the way estates are. And you just need to know how to navigate um, through it. It's very time consuming. Being an estate trustee requires a significant time commitment. So make sure you schedule yourselves a number of hours per week to deal with the estate. It takes time. It can be well over a year before probate is complete. And then, of course, if it follows into a second year, you're back to the board of having to do a tax filing for that second year, not just the first year. It involves locating, organizing documents. I mean, documents like crazy. There could be, well, there's definitely the will. There could be handwritten things, from the deceased. Uh, Again, it involves communicating with financial institutions and banks. They're not easy, folks, let me tell you. I'm dealing with, I don't know, 4 or 5 different banks, and it has been incredible. You have to drive. They will not do stuff over the phone. You need to bring a copy of the will, a copy of the death certificate. I would suggest bring the will to the estate lawyer, have them notarize a couple copies because a few of the banks will request keeping a copy. You need, I would say, at least 10 notarized copies of the death certificate and 10 notarized copies of the will. Should be plenty. You need to make sure all the tasks are completed accurately and in a timely manner. Get yourself a book, get yourself a planner, write down daily everything that you do, every communication that you've had, whether it was with the bank, whether it was with a family member, whether it was with the lawyer. Write it down. There's a huge challenge when you see, and I've had firsthand, and not just, I'm not saying my estate, don't get me wrong here, but with other clients where I've been selling homes, things like that, things like the will have gone missing, things like, sorry about that, things like the deed for the house or a handwritten promissory note. These things go missing, and the reason is, again, key things like the will, handwritten agreement, stocks, bond certificates, toys, computers. Things go missing. The first thing you need to do as the estate trustee after the reading of the will, when you know you're the estate trustee, get over to that property, document everything, inventory everything. Even if it didn't belong to them, you can cross things off the list, but get an inventory because things conveniently go missing. The financial complexity of being an estate trustee, you have to manage the financial aspects of the estate, including the investments, taxes, the debts. You need a good understanding of the financial matters and a lot of mistakes that can happen. And what happens when, the lawyer, the estate lawyer, will apply for probate. They'll send you a draft, go over it, check for spelling, stuff like that. Things can be missed, and it happens. The good thing is, if you find something down the road after the application's been set, you can always send I forget what they call it, like a remittance type of an amendment to the estate application, the probate application, to the courts, and attach it to the original application. That's the way they do the amendment. And it could be something as simple as missing an E in a name. But, don't come down on the lawyer. Mistakes happen, and you can get that done. You need in Ontario, it's a lot different. So please know that I'm talking about Ontario. You need to familiarize yourself with the responsibilities and the legal obligations of an estate trustee in Ontario. You have a duty to keep the paperwork for 7 years. Yes. So get a banker's box and a spot in the corner of your closet to put those papers in and keep them there. This includes any tax filing, legal documents, the probate certificate, the whole bit. There are a lot of available resources online. You just have to know where to find them. Your first thing would be to go and get yourself an estate lawyer, a probate lawyer. And you can get guidance from the Ministry of the Attorney General. Most banks have guides that you can take home and read as well. A word of caution: don't deal with the bank where the deceased did their banking. Couple reasons: they can seize accounts, they can freeze accounts, a whole bit. Your estate account, once probate is done, you have to open an estate bank account. That's where all the monies go in, because you want to be able to have reconciliation for all of that money, but you don't want it in the bank, especially where the monies were owed. You want to let the lawyer do those disbursements. Always consult with professionals, definitely a probate lawyer. You need an accountant with estate experience. Don't just hire your brother, your sister, because they know QuickBooks. You need an estate accountant, somebody who knows estates, financial advisor, if there's a great deal of money involved, to help get you through the process. They can provide expert advice and help to navigate you through the complexities. You need to stay organized and communicate, keep detailed record of all the transactions and communications relating to real estate. Maintain open communication with the beneficiaries if they're maintaining communication with you, and keep them informed about the progress and the timelines. It's not a requirement by law that you have to maintain that information with the beneficiary at that time, but before the disbursements, they have a right to appeal anything. So this is why you have to write everything down. And it's always good to keep them happy. So that's why I'm saying communicate at all times. If the communication breaks down because of entitlement, spoiledness, whatever it is, they don't think you're doing something right, back away and back away. You need to do your job without being stressed because they can't get their heads on straight. It's that simple. Clear communication, manage the expectations, will always prevent misunderstandings. Again, unless you're dealing with people, as I mentioned in the beginning, with narcissistic behavior, then of course anything you say isn't going to help the matters. So always, maybe refer them to speak with their own lawyer on what they can do. And remember, their lawyer is not costing the estate money. Follow the will, follow the law. Ensure that you're following the instructions outlined in the will. If you don't understand the jargon in the will, have the lawyer detail it page by page, paragraph by paragraph, line by line. There are all kinds of instructions to comply with Ontario and the law, and includes obtaining the certificate of appointment of a state trustee, paying the debts, paying the taxes, and distributing the assets according to the will. If the will doesn't specify the assets, it will still specify how the balance is to be paid out. For example, if they had a whole bunch of different things, stocks, bonds, cars, house, real estate, it will just say something to the effect of taking all of my assets, liquidating, and paying the debt, then dispersing to the beneficiaries. You should always seek, of course, court approval for certain actions. If there's disputes between family members, somebody doesn't want to sign the sale of a property, if there's two beneficiaries, two owners, anything like that, and they start disputing, you can seek legal judgment to force the sale, to force the acquisition, to force, provided you have enough information and enough validity that your reasoning is correct and substantiated for the estate. Every estate's unique, folks. The information I'm giving you here should not ever be construed as legal advice. Always speak to your lawyer, speak to an accountant. I'm just trying to give you some help. I'm going through it now. It's different because I could always guide my clients in an estate sale of speak to your lawyer, speak to your accountant, speak to this, speak to that. Here's a pamphlet. But when it happens to you, it's so much different. So please take my advice. Get some help if you're an estate trustee. Reach out. You can reach out to me if you'd like. I consider myself experienced now. It's been an incredible journey, to say the least. love my aunt dearly. I just want to see this all done and her name cleared. And it's experience. That's all I can chalk it up to. And going through some of these horrid things is helping me teach others. So I always look for the positive and the light in the dark. I want to thank you for joining me today, showing up to watch this video. If you have any questions, give me a call. It's Jason Steele, broker, your Grey Bruce Simcoe real estate broker and professional realtor for life. Thank you so much, folks, and I wish you all the best.